Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. As we previously reported, the deadline for the extremely important motions in limine were due today, which is February 24th, 2025. The responses are due March 17th, 2025. The replies to the responses are due March 24th, 2025. And then finally, oral argument or the hearings on the motions in limine will be entertained by Judge Stephen J. Hippler on April 9th. And if necessary, they will spill over, if more time is required, to April 10th, 2025. Now, what is a motion in limine? This is, as we know, a motion is an application for a court order where the parties are filing motions asking Judge Stephen J. Hippler to keep certain testimony, to keep certain information. It could be documents, it could be exhibits out of the jury trial. So it's as if whatever they're looking to have thrown out does not exist for purposes of what will be or could be introduced to the jury by the state in seeking to persuade that jury to return a verdict convicting Mr. Kohberger, or if it's the defense that we're talking about, to raise reasonable doubt and to have that jury come back with a not guilty verdict. The case summary page maintained by the clerk of court for Ada County, which documents all of the key events in the case. It could be hearings, it could be court orders, it could be the briefings, motion, response, reply. And today we note that actually on Friday, which was the 21st of February, the state filed 4 motions in limine. Now, this does not mean by any stretch of the imagination that this is all that the state's going to be filing, because they have, as does the defense, until the 24th, which is today, to get those motions in limine in. There is a possibility that additional motions in limine were filed by the state on the 24th that have not yet appeared on the docket. I would be extremely surprised if we don't see motions in limine from the defense. Just because if you look at the case summary page for this case, if you go down to page 70, you're going to see just the state of Idaho's motions in limine. I don't for one moment expect that the defense has blown this deadline. I quite frankly expect that in the days to come, we're going to see the defense's motions in limine filed on the case summary page, and then hopefully on the docket if they're not filed under seal. Let's look at what the defense or the state has filed in terms of a motion in limine. Well, the first is state's motion in limine regarding alternative perpetrator evidence. I'm going to come back to that one. That's extremely interesting. The second, state's motion in limine regarding neuropsychological and psychiatric evidence. The third is the state's motion in limine going to the defense's alibi defense. And then fourth, state's motion in limine regarding admissibility of demonstrative exhibits and memorandum in support. Now, unfortunately, none of these 4 have yet to hit the public docket. They have, note, the PDF icon, and we know by looking at the case summary page when the clerk identifies documents that have just been filed with this PDF icon as opposed to the lock and key icon, This tells us these are public documents. They should be appearing on the docket. There's nothing around them to say that there's anything filed under seal. So it appears, unless there's going to be something that follows this filed under seal, that the entire motions are going to be published on the court docket. So we're going to wait and keep monitoring this docket and see when these actual filings hit the court docket. We'll discuss them when they do. But let's look at this one. State's motion in limine regarding alternative perpetrator evidence. Now we have to make educated guesses here because we don't have the motion in front of us. So that's a caveat. As we always do, we provide our First Amendment free speech going to what this could possibly be. Best case scenario, the state is looking to keep out any and all evidence, whether it's testimony, whether it's documents, whether it's exhibits, whether it's other sorts of information. It could be expert testimony. It could be a layperson testimony. They don't want this information about a possible alternative perpetrator to Mr. Kohberger to reach the jury's ears and eyes when this matter goes to trial. That's why a motion in limine is filed, to keep the information out of the jury trial. Now, we have been privy just recently, as in the 21st, when the transcript from the closed and sealed hearing that was held last month on January 23rd before Judge Hippler at 9 o'clock in the morning, that the public wasn't privy to, we just got to see the transcript. It's a bit redacted, but in there is some testimony when Ms. Taylor, counsel for Mr. Kohberger, was conducting her examination of Detective Brett Payne. He is the lead detective in the case, the author of the affidavit of probable cause, about what appeared to be, or what she described as BLOOD, a stain that we learned for the first time, as she described it, was going from 2 to 1, the second floor to the first floor, not the second to the third, or the third to the second, or the first to the second. She described it as second to first floor, which leads me to speculate, if this is true, that this marking, if it's partial hand mark or something, might have been going downward, not coming upward. We have to wait and see. We have very, very few details regarding that other than what we have learned in the transcript. So that might be the sort of evidence that the state is looking to keep out of the trial. Ms. Taylor was very interested in that evidence and wanted to know if it had been tested, along with a glove that was also found with some BLOOD apparently outside of 1122 King Road. This might be, or it might be something entirely different regarding an alternate perpetrator to Mr. Kohberger that would tend to raise reasonable doubt. He doesn't have to prove his innocence. That's not how it works in the United States. It's the defense has the burden of proof at the beyond a reasonable doubt evidentiary standard. They need to bring in admissible evidence, which is why these motions to suppress were so crucial, because if any of those motions to suppress had been successful, then whatever the defense was looking to keep out of the case might have been kept out of the case. As we know, all 14 of the suppression motions were denied. But this is what the state wants done here. The state wants something having to do with a possible other perpetrator to be kept out of the case. Now, we are going to be able to hopefully see what this document says as early as tomorrow. Hopefully when the docket gets updated on the 25th, this motion and the other 3 motions in limine will then appear on the public docket. We can read them for ourselves. In the meantime, if you'd like to take a look at this case summary page and review these 4 items where they are, and also note the upcoming hearing on the 9th of April, that's also documented there. Please follow the link that I have provided here to the Idaho cases of judicial interest. You're going to have to scroll down away because there's a couple of cases before Mr. Kohberger's. Get to the Idaho versus Kohberger case with the case number. The first hot link is the case summary page. That's what you click on. Go down toward the bottom, and you're going to look at the top of page 70. That's where these entries are. If you have any questions, any comments, any thoughts, as always, please leave them here. Your feedback is very much welcome and appreciated. And if you like our content, please subscribe to the channel. It would really help us out a lot. This will now conclude this episode of the Indie Zone. My name's Kathy. Until next time, thank you for joining us here today.